welcome to Off the Clock. Today we're going to tell you all about the lawsuit some of Lizzo's backup dancers recently filed against her. There are many allegations in the lawsuit, and we're going to kind of cherry pick them out and see what we can learn from this lawsuit.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
I would have bet a lot of money that we would never be talking about Lizzo on one of our webcasts, but here we are.
People see us and think hip hop.
Yes, that's right. I don't know why I thought Lizzo
what they
wouldn't
want.
come up here. Give the people what they want.
They've been
indeed.
saying, yes.
Indeed.
Don't worry, we're not going to start singing.
We're going to leave that part to Lizzo, for
We
sure.
will leave that
Right.
to the very talented Lizzo.
Exactly.
But we thought we'd talk about this today.
Yes.
Because a lot of people, frankly, including me, before I dug into it, have seen the headlines, right?
Mm-hmm.
People know that some of Lizzo's dancers have filed a harassment lawsuit against Lizzo, but that's maybe all they know.
Right.
So we thought it would be fun to spill a little tea here, right?
Right.
Because we actually got the full document.
That is a heavy lawsuit. There's
It's a
lot
heavy
there.
lawsuit. I read it, so no one else has to.
Good.
They
Excellent.
can just listen or watch us. So we're going to spill a little tea on that so people will have enough to talk to their neighbors and friends about at the barbecues, right?
Sure.
About what is actually alleged in the lawsuit. But what we're really going to do is go allegation by allegation and talk about what our viewers and listeners can learn.
Right? Because really, anytime a lawsuit is filed, there are usually some lessons for the rest of us to take
Yes.
away, right? So
Correct.
this is no exception.
Right.
So this lawsuit is against the company itself, and then she and another individual are named individually as defendants.
Yes. And to be clear, this was filed in California state court.
Okay.
All claims are under California
Well,
state law.
lucky plaintiffs.
Which we will not dig into
Right.
here, but it is interesting. So first fun fact is that when it comes to harassment in many states, the individual accused of doing the harassment in a workplace setting can be named individually and be individually liable as well as the company.
Right. And that's true under federal law, of course, as well. So
That-
that's not an uncommon.
That takes a
thing to
lot of
happen.
people by surprise, right? You
does.
and I do a lot of litigation when an individual supervisor is also named. Usually the first question we get from a very nervous supervisor is I was just at work, right? Everything I was doing it because of my job. I can't be personally liable for any damages, can I? And the answer is
The answer is yes.
potentially yes. Right.
Potentially, yes. Okay.
Okay, so that's first lesson learned. Let me just go over the basic facts, then we'll get into some of the specific factual allegations for
Tell
those.
us all about it.
I know, right? Here's the tea. All right, so for those that didn't dig in, right, to the actual 70-page complaint. First of all, we should mention that these are all just allegations.
Whenever we're talking about the complaint, we're talking about things that are only allegations right now.
Correct.
We have no idea if they're true or not. We're just reporting back
We're
what
telling
the
you,
allegation
We're telling you
alleges.
what the allegations are.
Okay.
We'll leave it for the court system to sort out
What's true
what the
and what's
evidence, or maybe better, what the evidence supports. And
Yes,
what it
okay,
doesn't,
got
right?
it.
Okay. So the basic allegations. There are 3 plaintiffs, all of whom were dancers on Lizzo's tour and live shows. 2 of them competed in Lizzo's reality TV competition show, which apparently streamed on Amazon, which I was not aware of.
I missed that.
Okay, so
Yes,
this is one of the
right.
another good takeaway. Now we have something new to watch, where dancers were competing to be backup dancers on Lizzo's
to make
tour.
to
make the dance
selected
team.
for their
You got it. So that's how 2 came to be employed by Lizzo, and there's an admission here that they were employees. All right, so all 3 were employed by Lizzo as dancers, 2 because of the reality TV show, 1 because she tried out. They toured with her around the globe, and they raised all sorts of allegations that could probably broadly be characterized as a toxic work environment. That's a kind of a catchphrase. Right now, they raised allegations about being harassed, sexual harassment, ADA, right, disability, harassment, all kinds of things, and
Okay.
even some privacy issues. I'm not going to repeat all of the allegations in the complaint because, frankly, some of them are too much any time of the day for us to talk about and for our folks to listen to. But let me just go over some of the main allegations, then we can talk about what we think of that.
Okay.
One of the plaintiffs alleges that at the time she was on the tour, she was a virgin, and that the dance director, for religious reasons, thought that was admirable.
Okay.
And in the course of communicating that, she did so very publicly over and over and over with lots of other people and would share that information with other people, which this plaintiff alleges was very embarrassing to her to have her sexual life discussed publicly like that. The same dance instructor, ironically enough, allegedly would joke about performing oral sex on a banana, talked about her own sexual habits and fantasies in front of the group. And then there would be outings on tour to strip clubs and that sort of thing.
Okay.
Overseas. The plaintiffs alleged this created a sexualized environment at work to which they objected to, and then all the other standards that we're familiar with. It made them so uncomfortable, it interfered with their ability to do their jobs,
Right.
etc. All of the behavior of management that they complain about, and some of the specific allegations are against Lizzo, not just the dance director. Let's be clear about that, but I'm not repeating some of those. Were all done by women. There's no allegation that anyone was gay, right? So let's just assume, for the sake of argument, that heterosexual women creating a sexualized environment, no one hitting on each other, asking each other out, no quid pro quo. So let's just pause with that set of allegations.
And
again,
sort of-
they're just allegations, and there's certainly more detail that we could talk about, but we're not.
And sort of applied the legal framework that we know, right? Which is harassment is unlawful if either it's quid pro quo, right? We talked about that. It doesn't sound like there's allegations that these dancers were pressured to engage in sexual acts, and if they didn't, it would negatively impact their job. Alternatively, it could be unlawful if it created a hostile work environment, but only on the basis of a protected class under the law, right? So I understand what you're saying, which is this may have been sexualized or sexually charged, right? It may have been intimidating and offensive to the dancers, but do they have an argument that it's founded or couched it on a protected class? And they're all in the same protected class, it appears to me, right? They're all women. Are they of the same race for the most part? Does it appear? Okay.
It appears, I'm not 100% confident on that, so it appears to me they all identify as
And I
Black
would
women.
imagine around the same age, right? So they're all in the
Well,
same...
they can dance on tour.
Yes,
so
exactly.
They're younger than us.
The same or pretty much the same protected classes. So what we have here is a sexually charged work environment that, in my mind, is going to be hard to turn into a legal claim of discrimination under the law, right? Is it a good idea to have that type of work environment? Of course not, right?
So I have I agree with everything you said. I think it is possible to have what we call a same actor, right, do the discrimination. So I think theoretically it is possible to have, let's just use this example, a straight female create a sexualized environment for other straight women, and that could rise to the level of a hostile work environment.
Right.
If it was done because the plaintiffs
what
were
I mean.
women.
Were women.
So the fact that the alleged wrongdoers here, right, we're of the same gender, same sexual orientation, etc., is interesting, very interesting. But to me, the determining factor, if someone's really going to apply the letter of the law to this, right, at least under federal law, is it because the plaintiffs were women? And some of the allegations include events where men were also there.
Oh, that's really
So
interesting.
if they are creating, if Lizzo and her, right, C-suite, if that applies
Right.
to a touring company, Lizzo and the C-suite are creating, if they are creating a sexualized environment for both men and women without any regard, right, to the
Right.
gender identity or the sex of the people in the room.
That's going to be hard to turn it into a legal claim, even
Yeah.
in California.
Yeah, I'm not going to profess to be an expert on
So-
that part of it, but it is, I think that is something a lot of us lose, not our defense attorneys, but the general public and right. We are so sensitive, and not wrongly, but sensitive to any sexualized statements, conduct, whatnot in the workplace. Right? That sometimes we forget what the legal standard actually is.
I think that's right, although I will add this because I think the plaintiff's attorneys who filed this lawsuit are well aware of this legal hurdle as well.
Mm-hmm.
My guess is they moved forward with that claim and leaned heavily into it because they knew it was embarrassing.
Oh,
Which provides
for sure.
a lot of leverage, right? So I understand everything that you're saying, and maybe at the end of the day, Lizzo will succeed in getting that part of the complaint dismissed, but not until after even an HR webcast in West Michigan is talking about the specifics of the allegation, which might actually be more damaging to Lizzo than the legal claims anyway.
I
right?
thought about that many times reading the full complaint. There, It was that this was more of a practical, right,
is
settlement issue.
Yes,
Settlement demand.
I'm going to
essentially.
embarrass you to create leverage,
Right.
and that's true even on a smaller scale, right? With
yes.
much smaller employers and businesses, when behavior like this is occurring in the workplace, might really great defense attorneys like you and I, right, be able to make arguments to say, well, a legal claim doesn't exist.
Right.
Sure. But does that mean it's not otherwise going to be embarrassing for the organization if this information becomes public?
So and so, the HR director of a local
Yeah.
company did create a sexualized environment and take direct reports to strip clubs, etc. But they did it for both men and women. I mean,
Right.
do we really want to make that statement publicly
is
for your
that really our
organization?
favorite
Is that
defense? Right.
right? Going to be a proud moment? Probably not.
Right.
But I do think that's interesting. I did perk up every time I saw that they mentioned that there was a male around. Now they only mentioned it once, but I have a feeling in discovery the defense team will dig in on that. One of the reasons I like this lawsuit complaint is it covers the gamut of employment law. This is like an employment law treatise, kind of. So we talked about harassment issues. We're going to get to disability and other things, but why don't we take a breather and talk about non-competition?
Okay.
And intentional interference with
this is
business
interesting.
relationships. Now, that's a mouthful. A lot of lawyers don't know that. I mean, a lot of people who are not lawyers don't know this phrase. But there is this, put the non-compete issue aside, there is this concept under the law that you cannot interfere with others' contracts or business relationships wrongfully, right? Fair competition is fair, right? But unfair competition includes that sort of thing. It bleeds into non-compete issues when we talk about the specific allegations here. There is no allegation that there was a non-compete agreement, by the way, but the dancers alleged that they were told they could not work for anyone else, do dance for any other company or employer when the tour was, when they were not dancing for Lizzo. In other words, they needed to be available and on call, essentially. Not on call like in the healthcare context, but they didn't want to be otherwise occupied. So if Lizzo got a gig, right, or a date or something, they were available, right, to go. This actually became quite an area of dispute between the dancers and the production company because they found out that others, not dancers, but musicians, others, were getting paid, right, to agree to not sign on to any other commitments.
But the dancers were not getting
But the dancers were not, yet they were told don't sign on to any other commitments. Tell your agents not to book you, right? et cetera, et cetera. And that became an area of dispute, actually. But for the purpose of the complaint, they alleged that was an intentional interference with their prospective business relationships.
Wow.
So I thought that was very interesting. What do we think? So there again, there is no allegation of a non-compete here, probably because, as you know, non-competes are illegal in California. So there could, if we're in California, right, Lizzo and her company could not have even asked them to sign
a non-compete, but it essentially said you're not allowed to work.
What do you think about if there was a non-compete? What do you think about
So
that?
two things, because this is in California, my guess is there might be some helpful California case law here that's unique in California.
Yeah.
But I will say that concept of telling employees that as long as they are employed for that organization, they are not allowed to have outside employment. That is not an uncommon idea
very common
at all, right?
Yes.
So when
We
you
both
said
look at
that,
a lot of
I
handbooks.
went, that's in a lot of handbooks.
Yes, sure is.
Particularly, for example, even if a business doesn't have a broad prohibition like that, they do often say if you're on a leave of absence, for example, if you're on FMLA leave, you're not allowed to engage in other employment or self-employment.
Yeah.
So I will be interested in following where that claim goes. My instincts say that's a stretch, and maybe there's something unique in California law that's making those plaintiff attorneys think they have something there.
We're going to pause here. Sarah and I are having so much fun talking about this lawsuit. We just can't fit it into one episode. So we'll see you next time.